Good morning.
Good morning.
That's a nice introduction. I have worked with the family for several years. Great operators, great businessmen, very smart. And one of the things that they realized early on in real estate transactions, particularly commercial, as it was mentioned, that in residential, I don't get involved very much. I get involved when there's problems, not when things are just going transactionally. But in commercial work, we get involved usually pretty early, particularly by operators, owners, developers, buyers who have sophistication. They've done a deal before, they know the pitfalls, or brokers who represent people who don't have that experience, but who understand the value of adding a partner to the transaction in the form of an attorney who's going to help keep things going smoothly, make sure the parties get the deal that they want to have, and not the one that they think they have. Sometimes that's two different things. One party thinks he's getting one thing and the other party thinks they're selling something different. So what is very valuable and what the experienced sort of developers and sellers, they understand that if we can take care of a lot of the terms in the early stages of the negotiation. So in residential, you'll send the form offer. In commercial real estate, you're going to get a letter of intent, typically, is the way the transaction is going to start. One of the values of having an attorney early on, and then also a broker or a party, a seller party or buyer party who has some sophistication, is we can handle the toughest terms early. Because one of the things that gets expensive, because we're expensive, attorneys, we are not cheap usually, and you do get what you pay for. So if you get someone who's very cheap, there's probably a problem. But I think one of the things, if you're using prophylactic legal work, I talk about that all the time, protect yourself early. So by engaging counsel early, you can save thousands and thousands of dollars, and in some cases hundreds of thousands of dollars in litigation. If you're able to bring in counsel early, make sure the parties understand the contract they're signing, both parties understand what they're getting, and then you can avoid some of the issues that get very expensive later on in the game. So a few $1,000s of legal work early on in a multi-million-dollar transaction can save hundreds of thousands of dollars at a later point when we have a dispute because something wasn't written properly, something wasn't negotiated properly, understandings weren't there, or in a lot of cases, the due diligence wasn't done properly, where on the seller side they didn't disclose everything, or the buyer side they didn't investigate everything. So using an attorney early on in the process, it's not mandatory, but it's definitely something that I think is a good idea. And it's important to talk about what a contract is. And I mean, I think we all think of the things, how many people have just signed a contract without reading it? I'm sure plenty of you have, right? I've done that. I mean, when you get the contract, the guy who's going to get rid of the rats at your building, you sign the contract, you don't even read it. Well, what it says in there is it's 18% interest if you don't pay within 10 days, and his billing requirements are nothing. So you don't even know what he's done, and he's going to charge you, and you want to dispute the bill, and then you owe 18% interest, things like that. So what I tell people always when we talk about contracts, it's like having the rules of the game. So we're going to play freeze tag. Well, where's the base? Is it two-hand touch or one-hand touch? What are the rules of the game? And up front in a real estate contract, we want to set forth the rules of the game. So there's no dispute later. Well, that's not what we were doing. We write it all down. We put it into a place where we understand if this happens, then this happens. And that's actually something important for brokers. If you're even taking a form contract and you're doing an addendum to it, and you write the words, if this happens, then this happens, you're crossing into a dangerous place of practicing law. And if you aren't licensed to practice law, it exposes you not only to liability with the state of California, but your clients, if you're doing that, can dispute your transaction later and make a claim against you for drafting a contract term without having the proper experience or license, and now you're liable. So if you're writing the words, if this happens, then this happens, your safest thing is to have your client write those terms, because he can represent himself or she can represent himself, or have an attorney review it before it goes out. So in real estate, like I was mentioning, commercial real estate, it's pretty much standard practice. We're going to get a letter of intent. It's the first real attempt to negotiate the terms of our contract. You're going to show the space, the buyer wants to buy it, they want to write an offer, and so you we typically use a letter of intent. And that's written. And why is it written? Because we can use it later on in the contract negotiation and say, well, you already agreed to this special provision. We're going to talk about those in a minute. And if you've agreed to this special provision letter of intent, it's not binding, but certainly as a broker, you want to make sure your client understands if we're doing a letter of intent and you're agreeing to this term in the letter of intent, the other party is going to expect that you're going to stick with that term in your letter of intent. Now, not every buyer or seller wants to do that because they think, let's get into contract negotiations, let's get them on the hook, and then we'll close the deal. Well, that ends up costing a lot of money because the two attorneys are going to fight about a provision that was agreed to in the letter of intent that is not being adhered to in the actual contract document. So, some information that's going to be important in letters of intent, and it's from the broker side. You're going to save your client a lot of money with the lawyers. Make sure you've got the parties' names, legal names, correctly stated. Make sure you understand who the person's going to sign the contract is going to be. Are they the managing member of an LLC? Are they president of a corporation? We want to have a specific definition of the property, including the assessor's parcel number, square footage, acreage. All those things are broker side information that if you provide to the attorney, it saves your client money, because when I pick up the phone, brokers are getting paid commissions. We work hourly, so when I pick up the phone and make a phone call to ask what's the name of the managing member of the LLC, that's costing the client money. And if the brokers do a good job up front, and I work for some great brokers, and when I get a letter of intent from some of these brokers, it's almost like I can cut and paste the document into my contract. So obviously the property is very important. And then we get into the main things. What are the rules of the game? What am I buying? How much am I paying for it? When do I have to pay? Those are pretty much the most important things in a real estate contract. The thing about real estate, unlike a lot of other transactions we might do in our society, is California law requires that any transaction in real estate be in writing. Not any, there's a couple exceptions, leases for less than a year, but most transactions have to be in writing to be enforceable. So your client, if they have an oral agreement to do X, Y, or Z, that agreement doesn't mean anything under California law with some very limited exceptions, and we'll talk about that when we get into the modifications of contract. Letters of intent, are they binding? Well, typically they're not, and there's language you should include in your letter of intent. There's some language, and I took a sample that I'm going to show you. It's not perfect. I'm going to show it to you because I want you to see why it's important, the goods and the bads, but it's got a lot of the good stuff. But at the end of the day, the letter of intent should absolutely include language that says this is a non-binding expression of the party's intent on terms that they would enter into a written contract at a later date once it's been formalized. Because if you don't have that language and there's a dispute and you can't come up to a contract, that buyer could say, you've already signed the letter of intent. It says that this is the deal you're going to make with me, and this will fill in the rest of the blanks later, and that's what a court will do if you have a dispute. So that's really important. So typically they're not binding, but they could be. So you have to be very careful. So this is a sample of a letter of intent. It's kind of small. I guess you guys can see it all right. And again, this is a form. I've scrubbed it. I've used my family's Greek, so I used some Greek names in here. But we have the party, in this case, this is the letter of intent on behalf of the seller. It's going to the buyer. We know who he is. We know we're identifying. We identify the lots in the Alexandra 3 community if you go down to the first paragraph. Again, probably the most important language that you can have a letter of intent. This non-binding letter of intent, okay, that's the first language we want to see, because we don't want anything to be considered binding just because you've expressed an offer. Because under the law, the contract can be formed when there's an offer, it's been accepted, and there's some form of consideration. So consideration is a very loose term. That could be the agreement to actually close the deal can be considered consideration. So typically, you'll see a contract, it'll say, especially in commercial, the portion of the deposit is going to be released in the amount of $10, and that's passed through to the seller no matter whether the transaction closes or not. Because some people have contested whether the obligation to buy a piece of real estate or sell a piece of real estate is consideration by itself. So we get into the property, and this is where I think it's really important. One of the terms in this agreement, again, I didn't write this letter of intent, but it was the transaction I did, and I've scrubbed it. But if you look at where it says the property is 72 tentatively mapped lots known as Alexandra 3, and then this is important language, on the illustrative site plan for the specific development plans for Alexandra 3 dated July 28, 24, prepared by this company, Gillies Inc. Why is that important? Because this gives us an exact description of the property that we're selling. We might not have a parcel number yet. In commercial real estate, a lot of times, like in this transaction, it only had a tentative map. So it wouldn't have parcels yet. It may have a parcel number, but it wouldn't have a specific description that fits what's being sold, which is 72 lots. It might be part of 400 lots. It might be part of a property that isn't even zoned yet. This one case had tentative map lots. But we want to describe the property here so that we know what's going to go into the purchase and sale agreement in the future. Ideally, if you can as a broker, and there is a legal description, include the legal description as an exhibit to the letter of intent. Why? Because I'm going to have to look it up anyway. And I'm probably going to call you and tell you, I need the legal description, get it from the title company. And I'm sure you all have seen what a legal description is. There are descriptions like from the property boundaries and those things. We want to know exactly what's being sold. And if we can put in an assessor's parcel number, that's great. But if we can't, we need to do some form of description that is going to identify the property being sold. In this case, this is where we get into some specific terms. In this case, the buyer was going to be responsible for obtaining the final map. And I don't know if you, well, I'll kind of do this quickly, but we can talk questions after. You have, in the map process, you get a tentative map granted to you by the county or city, and that will have conditions for approval. And then once you've met all those conditions, you'll get the final map, which probably will also have more conditions because city entities and counties love to give you more conditions. And then that will create the final parcels that can be legal parcels that meet Subdivision Map Act requirements and can be sold. So in this case, a specific provision, it's very important because if it doesn't say this, arguably the seller is responsible to get the final map. In this case, the buyer had agreed to obtain and record the final map. Of course, the purchase price, we want to make sure we have that. All cash, that means we're not going to have seller carryback, there's no credit. That's typical, I'm sure you've all seen that. So this is where there's an example of a very specific provision that was unique to a contract. Why did I show you this? Because I wanted you to see where something that is very complicated to negotiate in the final purchase agreement was negotiated before the attorneys really got involved. And this is where the definition of a finished lot was. And in this case, the seller was going to finish the lots after closing and had a special agreement that I'm going to enter into a contract and I will finish these lots for you. I'm going to grade them, I'm going to stake them, I'm going to put all the different utilities to the sites. I'm going to do that work for you. Why is it in the letter of intent? Because it's not work that was part of the purchase, but it's part of the price. So the seller was willing to give a slightly discounted price in this case because his company was going to do the work and build the finished lots. And so he had a set price on the lot price, $4 million. The finished lot definition is very specific. And why is it specific? It's specific because these are the rules of the game. So at the end of the day, if the seller says, I'm done with the lots, here's my notice, the lots are finished, and the buyer comes out and looks at the lots and says, I don't think these are finished. Well, why not? In this case, it talks about exact specifics about what constitutes a finished lot. Here are the rules of the game. So we want to be very specific when we can be, and especially when it's something that's complicated or unique. If we were simply selling a piece of raw land and there's no map entitlement, it's as is, this letter of intent will be very different. Price, closing date, due diligence period, inspection documents. And we'll talk about each one of those things as we go on. But that's all it's going to say. But in this case, because the seller had a very specific advantage by doing this commercial work, he wanted to make sure that that was in this agreement so they would make it into the final contract as a mandatory term. I, the seller, get to do this work. And in this case, he could say no and the deal would fall apart, or during due diligence, or yes, I'm doing this work, I'm getting paid $4 million. So he discounted the price from $8 million that he was going to sell it for to $6 million because he was going to get profit on his construction work, and also he knew that the deal was going to get done on a specific timeline because he was doing the finished lot work. Okay, so delivery of the PSA. This is always an interesting one because a lot of times you're going to get a buyer who wants to use their purchase agreement, the seller wants to use their purchase agreement. From the attorney perspective, it's about the same time either way. I'm going to get a document from a seller as a buyer's attorney, and it's going to have none of the things that I need in it. It won't have disclosure obligations. It won't have certain closing requirements. It's going to be advantageous to the seller, and that's why the seller wants to use their form. And it's the same thing for the buyer, it goes the other way. Now the reality is, particularly in commercial transactions where there's going to be more than one attorney involved, you're going to end up with a negotiation between the attorneys that's going to get us to basically a middle ground. So that's typically what happens. Unsophisticated buyer, you might get away with one as a seller. Typically sellers of commercial real estate are more sophisticated than buyers a lot of times. There's a lot of doctors who I've represented over the year who decide they want to be real estate people because they're tired of being doctors. They don't know anything about real estate, but they know everything about everything. So they will tell us what they want to do in their contract, and they have no idea what they're doing. So maybe you might catch a doctor who's a sucker, but typically, I'm sorry to bash on doctors, they do great things. But in this case, the seller was going to deliver the purchase and sale agreement. And this says within 5 days. There's an actually important term, it's the third word, delivery PSA, seller shall endeavor. What does endeavor mean? Well, it means they're going to try. They're not saying seller shall provide the agreement in 5 days because you never know what's going to happen. The broker that may be unable to get a hold of the seller to get some key terms. The attorney might not be available. So we don't want to write something, even though this is non-binding, we don't want to write something that's going to start out off the very beginning of the transaction where we don't meet an expectation. So in this case, endeavor was important. And then another important term in this paragraph was the effective date should be the date all parties have executed the agreement. Why is that important? Because we're going to have a lot of triggers in the purchase and sale agreement that go off the effective date of the contract. So the contracts will often have a date at the top. Mine says for reference purposes only for a very specific reason, because two sentences later it says the effective date is the date all parties sign this agreement. If the contract says July 4th, 2024, and we sign it today, and it doesn't say the effective date is the date everybody signs it, there's an argument that the date was July 4th and that the due diligence periods run from July 4th, or the closing period runs from July 4th. So we want to be clear in our contracts. Again, this is one of the rules. It's effective when it's signed by everybody, not signed by one party. So in the case of a seller, I'll give you a quick example. If I provide a signed copy of my contract and it's not signed by the buyer, and the buyer hasn't turned it back to me yet, technically that buyer has a contract that's binding the seller only. So it's almost like an option. That person could hold that document, sign it later, look for other properties, and so, but the seller would be bound, including selling that property to them, even if they didn't want to and they found another buyer, as long as they signed it and sent it back to the seller at a later date. So typically, you're going to see effective date signed on both parties. In fact, if it's not in there, I think it's a mistake. So the next issue is deposits. Okay, and deposits can be lots of different ways. We have non-refundable deposits where if you want to make this deal with me, you're going to give me $100,000, and that's a seller. And I'm going to keep the $100,000 whether you close the deal or not. There's non-refundable deposits except for default by the seller. So that means the deposit's non-refundable unless the seller defaults. There's pass-throughs, which are additional deposits. There's releases of deposits. This is really important language because a lot of times a seller, especially when you have a long due diligence period, and in commercial real estate, we'll see it's not 30 days typically. 30-day due diligence period in a real estate transaction means the parties have probably done most of their work before they even get to the letter of intent stage. They've looked at the property, they've reviewed the documents, the seller's probably provided the documents. But typically, you'll see 90, 60 really is kind of the minimum for a typical commercial transaction because you're going to review a lot of things we'll talk about. And then the inspection period, this is the period where the buyer is not yet bound. The buyer can walk away at any time for any reason. They might find a better property. They might decide that the property's got too many flaws or whatever. So it's really important to discuss deposits. The first deposit is typically made right at the beginning of the transaction, but then pass-through deposits, continuation payments. If I want to continue my due diligence period, so I've done my 90 days, it's about to expire, but I've pre-negotiated additional continuation notices to extend my due diligence by paying $10,000 for every 2 weeks, or $100,000 in case I had one that was $1 million a month on a $20 million transaction to continue the inspection period, because he had multiple buyers and this was top dollar property. So you have to be very careful. The attorneys will handle the drafting side of that because you can't have penalties in California contracts, but in any event, the deposit language is extremely important. Escrow at the bottom, it's funny. I've done this for 22 years. And for the first 18 of them, I don't think I argued about who the escrow officer was going to be one time on a commercial transaction. There's not that many companies in Sacramento that have the experience, but typically we didn't do it. In the last 4 months, I can tell you specifically, I've had a dispute with the buyer and the seller, between a buyer and a seller on where escrow is going to be located. One guy wants it in Atlanta, the seller, she wants it in California, Lathrop, where she's located, and the property's located. And they've been negotiating that in the purchase and sale agreement stage, not the LOI stage, because it wasn't in their LOI. And they're having a fight about it, and it's really holding up the transaction. It was just resolved a couple days ago, but attorney's fees were spent. At my rate, it's $4.50 an hour. The rate for the attorney in Atlanta was $7.50 an hour. And so the two of us were on the phone arguing about who the title officer is going to be and where it's going to be located and why it wasn't negotiated previously. And that probably cost the clients in total between the two of them $2,000. For what? To identify who is going to process our documents? That should have been negotiated early. And so that's a case where I always make sure we identify the escrow company, the location, and if we can, the officer. Due diligence period. Okay, in commercial real estate, I was telling you earlier, due diligence periods are a heavily negotiated term. Why? Because buyers like to tie up properties during a due diligence period. The seller's bound, but the buyer's really not. It's almost an illusory contract, meaning the buyer has all the power. In this case, this is when I was talking about where there was a very short due diligence period. Why? Well, because this had been a negotiation that had gone on for 2 years. This seller and the buyer had worked on this transaction for 2 years. And all the buyer had seen every document the seller already had. They were in a Dropbox, which I'll talk about in 1 second. And they'd seen everything, so their due diligence period was extremely short. Also, the seller had other buyers that were starting. The market was changing at the time this was written. The seller was starting to get other offers and wanted to make sure he had a transaction. So 30 days was how long this buyer had to look at the property, make sure, and then close the transaction. At least commit to closing the transaction. So in this case, investigation materials, super important. So what are you providing as the buyer, as the seller? What are you going to provide the buyer? Are you going to provide your rent rolls for every tenant, every lease for every tenant, all communications regarding every tenant's lease? What are you providing? Well, typically we're going to list those in the PSA, and certainly if you can, you list those things in an exhibit to the letter of intent. This document didn't do that, but I will typically say we're going to list the categories of documents that are going to be produced to the buyer. Produced everything to the buyer, because later on, this contract, when the PSA is written, it's going to say, buyer has completed all its due diligence to its complete and total satisfaction and proceeds with the transaction under its own advice other than the warranties set forth by the seller herein. What's all that mean? I've given you everything, you've done all your research, you understand what you're buying, and you can't come after me later and say, I didn't get everything. How do we make sure they've got everything? We use Dropboxes now. It's the most efficient way to produce documents to a buyer in the due diligence period. And why else is that important? Because when you access the Dropbox as a buyer, it's going to show access by Rich Watts on July 30th, 2024. Why is that important? Because I can't come back and say later that I never saw that document because it was in the Dropbox on July 30th. It shows my access on July 30th. I've seen that document, or I've been deemed to have seen that document. So, and Dropboxes can be updated constantly. You drop another document in, you send an email to the buyer, you tell them you just dropped some new documents. Some of the Dropboxes have automatic reminders that say a new document has been added. And that puts this, again, the duty is on the buyer to review everything in the Dropbox. I have a transaction, we actually closed this morning. On the way here, I saw the statement that we're going to close. And the buyer in that case, during the due diligence period, never accessed the Dropbox, not one time. I mean, this is a $7 million transaction. They had never looked at the Dropbox. And they came back to us, they said, we need an extension of the due diligence period. My client had other buyers ready to go. And so we told the buyer, well, you didn't do any due diligence. Oh, sure we have. Well, here's our Dropbox report. You never accessed it one time during the entire inspection period. So how did the buyer stay in that transaction? Well, they had to pay for it. Price went up, paid for continuation fee, automatic pass-through. So investigation materials, broker side, probably one of the most important things you're going to deal with is providing the documents from your client to the other side, whether you're the buyer, if you're the buyer or the seller. There are buyer documents that go back and forth regarding corporate structure, but mostly it's seller side. By making sure that you've delivered everything, you protect, and everything means, in my opinion, over-delivery. So if they want to see current leases, I'm going to send them my lease file with every PDF, every lease, every amendment, every email regarding that. I'm going to send my rent rolls for 3 years. I'm going to send 3 years worth of tax bills. I'm going to send every possible thing I can to them so they can't come back later and tell the seller, you didn't disclose this, I want out of the deal. Or you didn't disclose this, I want money back. If there's been an ADA letter received by one of these plaintiff's lawyers by a commercial property owner, it should be in the Dropbox. Produce everything, overproduce, and that will protect you from somebody later on saying, I didn't see this document. Also, in the purchase and sale agreement, it's not in this document, it should also say that the buyer has the opportunity to request documents in writing, again, in writing, paper trails. We want to create paper trails. That's how we protect ourselves. Paper trails protect brokers, attorneys, buyers, and sellers all day long. If you have a conversation, send a confirming email. But in any event, having the list of over-disclosed items that they've seen, they can click on, they can look at, that's ideal for protecting both the broker and the seller. Including things like CC&Rs. If there's CC&Rs, they should be dropped in the Dropbox. Any county notices, if you've received a notice from the county that says, we're gonna take 10 feet of the property to expand Auburn Boulevard and make it 10 feet wider, so we're gonna condemn eminent domain 10 feet of the property. That stuff's super important, even if it hasn't happened yet. Disclose it, disclose it, disclose it. Delivery of investigation materials, this is where we said we referenced the online Dropbox. That's how we're going to deliver them to you. We're not going to hand you papers. Why aren't we just going to hand papers? Well, because if I hand you a paper, you can tell the judge later, he never did that. But if it's in the Dropbox, we know what happened. Okay. Possession upon close of escrow. This is an interesting thing that's happened over the years. I've been both on the litigation side and the transactional side. I'm mostly transactional now, but I had about a 50-50 split for about 15 years in my practice. How is the property being delivered? Are the tenants going to be under their leases? Am I wiping out my tenant leases and I'm delivering it to you vacant because the buyer is an owner-operator? What are you getting? Again, the rules of the game. What are you getting at close of escrow? And in this case, at close of escrow, what they were getting was a vacant lot with nobody on it, no leases, no licenses, no rights of possession, and that's what they're getting. So inspection period, this is the due diligence period. This is standard language. Buyer can do his due diligence. It's not really complicated. Closing date. This is actually a term that unbelievably gets litigated as much as any other term. When you get to the point where you've done your due diligence materials, you provided your due diligence materials, they've completed their due diligence, and now that's expired. They've even delivered their continuation notice, meaning we're going to proceed with closing. Some purchase and sale agreements say you must deliver a termination notice. I like to have the buyer deliver a continuation notice because it's an affirmative act by the buyer that says, I want to proceed, the deposit's non-refundable now, and we're going to close escrow. But what are they getting at the end of the day? Vacant with tenants on it? Is it a condition that the tenants still be on it when they close because they want the tenant to be there? What are the conditions? How is it going to be delivered? So what happens? You get to the closing date. And you go, how are we going to figure out when we're closing? Well, if the contract is clear, it's 30 days following the expiration of the due diligence period in this case. I know that I have a date, the effective date of the agreement. They have 30 days to do their inspections, and we're closing 30 days later. That's easy. Math is easy. We want math. We don't want arguments. We don't want, well, you didn't deliver the investigation materials on time. That extends my investigation period. It should be in the purchase agreement, and it's excellent to have it in the letter of intent. Okay, this is one of the example of specific terms. I mentioned it earlier, CC&Rs. If a property is subject to CC&Rs, and you know it is, which you typically will, it's a recorded document, you're deemed to have known it as the seller, you need to disclose those documents to the buyer. Now, there's a rule of law that if it's an encumbrance of record, that the buyer is imputed to have knowledge that that encumbrance exists. We'll find it on a title report. But it's upfront. Why do I want this upfront? Because I want the buyer in this case to know, in this specific case, the county is requiring that they establish HOA rules, have CC&Rs. It's an additional buyer obligation. They're going to have to pay an attorney to draft these documents. They're complicated, they're expensive, and they're going to encumber this property from now until those CC&Rs are terminated. Up front, the buyer needs to know this. Why? Because they don't want to get into contract and into due diligence. The buyer goes to the city and the city says, well, where's your CC&Rs? I want to see a draft of it. What are you talking about? Well, you need to have CC&Rs. In this case, they weren't recorded because they didn't exist, but the buyer was obligated to create them. Very specific term. It was negotiated in there. There was very specific, in this case, there was a Melrose bond, which included a tax rate that was additional to the regular property taxes. All of that was up front in the letter of intent, so the buyer knew exactly what the buyer had to do to close escrow. And that's an important example of when you need to do that. You should also disclose any assessments, any community, in this one, CFDs, community facilities. You need to disclose all of these things up front and make sure it's in your contract so they know what they're getting into. Closing costs, totally negotiable. A lot of times it'll just say pursuant to county custom. That's inviting a dispute. What's county custom? Who determines what county custom is? Title companies will tell you what they think it is, but that doesn't mean as much. Typically what we'll do is include exactly how we're splitting the fees. It's not rocket science, it's a negotiated term, and it is negotiable. I've seen it where a buyer approaches a seller who doesn't want to sell his property. It's an unsolicited offer, and the buyer pays for everything. So it's important to know upfront what we're doing. I love the last one on this page, the brokerage commission. Who cares about that, right? Nobody in this room. Very important to make sure that it's clear who the brokers are representing the buyer and the seller. If the seller oftentimes will come and they won't show up with a broker, and the seller's broker thinks they're making 5-6% of the total transaction, the purchase agreement goes out, and then all of a sudden there's an email from a broker representing the buyer. We're expecting their split of commission, expecting the seller to pay it, and this party has not been a part of the transaction until that point. But the buyer says, I'm not signing a purchase and sale agreement unless you pay my broker. Well, that certainly affects the seller's brokers, right? And it affects the seller a lot because a lot of times my clients will negotiate 6% if there's two brokers, 4% will go to you if you do it by yourself. That's typical of what I'm seeing. So you need to identify who are the brokers up front so that you don't run into issues like that, or the issue at the very end of a transaction where the seller is getting ready to close and there's a demand on escrow from a broker who's never been a part of the deal, and it's the same situation where they say, oh sure, I've always been the broker in this transaction. And maybe there's an email from 6 months ago where they talked about the property with you, and now they're trying to get a commission. So that's really important. Back to one other thing on commissions. Make sure, as the brokers, you have a written commission agreement with your seller or your buyer. It's the only way you're going to be able to enforce your agreement. If it's not in writing, you can argue it legally. Good luck. They're required to be in writing, and you should always memorialize it somehow with a document signed by your buyer or seller client to make sure you get paid your commission. That's why you're doing all this stuff. Okay, so right of entry, again, standard term that should be in every agreement. This dictates what can the buyer do during their due diligence period, okay? Are they allowed to drive by the building? Are they allowed to talk to the tenants? Are they allowed to look in the attic? What do they do? And if they are going to be on your client's property as representing a seller, there should be requirements. And this document doesn't really get into it, but the purchase and sale agreement will. And that is that you have to have insurance. You have to name the landlord, the owner of the property, or the landlord. You have to name them as an additional insured. Whoever's going to go do any work on that site needs to be insured to protect everybody. So that's a really important provision. Sometimes, and a lot of times, in a commercial building where there's tenants, the landlord doesn't want his clients to know, the owner landlord doesn't want the tenants to know he's selling the building. So how do you handle that? Well, you specifically state, buyer shall have no contact with the tenants. We'll have a confidentiality provision, which is the next sentence down, or next paragraph down. And I will provide you everything as the seller of the property regarding every tenant until we are ready to close escrow. And why do I say ready to close escrow? Because every lender that's going to lend on a commercial property will want an estoppel agreement from each tenant saying our lease is in effect, there's no money owed by the landlord to me as a tenant because the buyer would assume some of those obligations, and other representations that the bank's going to want. And so we want to make sure that we know, I don't want as a seller, my client, not everybody puts a sign in front of their property that says this commercial property is for sale. It can discourage leasing, it can scare off tenants from renewals. So it's very important to talk to your client, your seller client, and to see what level of contact do they want to let the buyer have with your tenants, with your occupants, your licensees. And that goes to the next issue is what can the seller do during the contract period with regard to each tenant? My clients will say as sellers, we can do whatever we want. Until you close escrow, we'll extend leases, we won't terminate anybody, but we'll do whatever standard practice we do, because if you don't close in 90 days like you're supposed to, and I just get your $100,000 deposit as liquidated damages, then I've lost the ability to renew this tenant. That cost me $1 million. So that's really important. Right of entry, what the level of contact, very specific term. In this case, it's a vacant piece of property, so they didn't have to negotiate that. But if there's tenants on the property, make sure you understand what level the owner wants to allow. Confidentiality, this is not in every LOI. In fact, sometimes the sellers don't want it because they want to create interest. So if you have a big box builder coming into your commercial property that's vacant land, Costco or whatever, Sam's Club, you're going to want to put up a sign, Sam's Club coming soon. Well, Sam's Club's going to tell you in their LOI, absolutely not. You're not doing that. We don't want you to do that. We'll dictate when we're going to market that. The seller wants to do it because he wants to attract all the other retailers that follow Sam's Club. You've seen those sharks with little things that stick on them, the fish that eat off of them, the remoras. That's what a lot of these tenants are. The little remoras on the big fish. So they're going to go to Home Depot, you're going to have a boot barn across the street, you're probably going to have a couple of little lunch-style restaurant places because they know contractors are coming all day. So you're going to see a boot barn with a Home Depot, almost every place you go, some form of that, right? So why you want to make sure you understand what level of disclosure we're going to have of the transaction. Sometimes it'll say until the continuation notice is filed, meaning we're going to close this escrow, neither party is going to do any marketing or any public disclosures. Again, some landlords say, I'm never going to agree to that. I want to disclose it the day you're in contract. It's going on my website because I'm attracting the boot barn. They're coming to follow Home Depot. True story. So that's important to deal with that. Times of the essence is actually hilarious because this is a ridiculous term that is implied under all contracts, but if it doesn't say it in the contract, it can be used to argue that you don't need to specifically perform. Times of the essence just means if you don't do this, is when you say you do it, there's no deal. Expiration of the proposal, kind of an important term. Why? Because if I send a letter of intent, it doesn't have an expiration on it, it's open until it's rejected. So if I'm representing the seller and I'm going to negotiate with 4 or 5 buyers, I certainly want to know that this guy who offered me the most money gets a shot for 5 days to do a deal with me and sign this letter of intent, we'll start the contract. But this lady, she's right behind him, and if he doesn't do it in 5 days, she gets it for 5 days. And if she doesn't do it, I've got another person. If it doesn't say it expires, until you revoke that thing in writing, it's an open invitation to close a deal. And again, this is non-binding, says it again in here, but we want to know, we're not going to talk to anybody else until this 5-day period's up, and then we're talking to anybody we want to. There's exclusivity clauses that you'll often see in LOIs. This one doesn't have it. What does that mean? It says, once we sign this LOI, I'm not going to talk to any other buyers until this period expires. Or sometimes it says until the contract is terminated. Those types of exclusivity clauses don't favor sellers because you want to be able to get backup offers. Why? Because a buyer who tells you on the last day of their due diligence period they don't want to close escrow, now you're a little bit married, you're kind of stuck in this marriage you don't want, and they can negotiate with you versus having a backup offer ready to go. So exclusivity provisions are very favorable to buyers. They're very unfavorable to sellers. I typically won't agree to them on behalf of sellers. Mine will say, we won't enter into any binding agreement, but we're going to be able to solicit backup offers during the whole time the contract is going. Liquidated damages. This is, I'm sure you've all seen it in the residential side, and in the commercial side, it's actually very different because we aren't limited on how much they can be to some extent. There's unconscionable liquidated damages. That's about an hour-long conversation in law school. We don't need to go through that. But liquidated damages means the amount of these deposits actually received. If you don't close escrow as the buyer, I get to keep them. The deal is dead. You go your way, I go my way. That's the seller remedy in almost every commercial real estate contract is liquidated damages. And we want to negotiate those to cover a couple of things. Your carrying costs, your cost for your attorney's fees, the cost of any inspections you're going to do. If you do a hazmat inspection, if you do a soils test, and that's on behalf of the landlord, your liquidated damages amount, the amount of that deposit, needs to cover those costs for the landlord. Otherwise, or the seller. So otherwise, it's a loser deal, right? They lost money trying to make this deal, and the seller or the buyer lost nothing other than whatever their opportunity cost. So let's talk about leases for a second, because this is a sale transaction document, but leases, there's some other terms that are really important in leases. Leases come in different forms. There's full service, meaning you pay a fixed rent rate for the whole term of your lease. So it's $3 a foot for year one, $3.25 for year two, and that's all the tenant pays. They don't pay anything else. There's modified gross, where the tenant pays that flat rate for the first year. Of course, they don't pay utilities or anything else. It's all included. And then there's modified gross, where we look at the first year is $3.25, but if our expenses, our operating expenses in the building go up, you're going to pay any expense that's your pro rata share over what the base year was. So 2024 is your base year, your expense is a couple $100,000. The tenant has 10% of that. They owe $10,000 more the next year in additional rent. So those are important things. CAM costs, common area maintenance costs. If you're doing a triple net lease, what's included? Because if the tenant thinks that he's only paying or she's only paying for security, property taxes, and parking lot maintenance, and then they get the lease and it says, which mine does, almost a page of things the landlord gets to recover from the tenants in the form of CAM charges or triple net charges, that's going to be a fight that we're going to negotiate. If you're representing a tenant, and again, that costs attorney fees. If you're representing a tenant, make sure when you get the LOI, if you've received one from a landlord or you're sending one, it has what you're not agreeing to pay. So a lot of tenants will say, we're going to cap our triple net expenses to 5% increases every year of the lease, or I'll pay no increase. Or I'm not paying for HVAC replacements. HVAC, big ticket item, right? So if you're a tenant, HVAC goes out, the form lease says the tenant shall maintain, repair, and replace the HVAC unit during the term of the lease. That could be $20,000 for your tenant that's paying $3,000 a month on a piece of property. And that's a big bill to get. So you need to make sure that you analyze what's being provided by the landlord and obtain the knowledge. And this isn't always easy. This is where the attorney can be helpful at the LOI stage. What's problematic about their common area maintenance charges? What things should we not pay? Sometimes the landlords will say, we get property management fee, we get all these other expenses, and we get a 10% landlord fee on top of the property management fee as a landlord's maintenance fee. You're double dipping. You're paying two property management fees at that point. You're paying 10% on the gross rents and 10% on on everything the landlord's paying as a tenant. That's not right, but it's often negotiated that way. So be very specific about that type of term. Obviously, rent rates are important. Options, there's the last thing I want to be specific about with regard to leasing, because an option to extend the lease for 5 years at fair market value gives you one thing. It gives you the right to make sure you can stay in that premises for 5 more years. What's your rent going to be? Fair market value is whatever the landlord really wants it to be at the end of the day, unless you agree to how do we calculate fair market value. You'll see this all the time in leases where it says, if we can't agree on fair market value, we're going to arbitrate it. You can appoint an arbitrator, I'll appoint an arbitrator, we're going to do an appraisal, and then if they can't agree, we'll appoint a third arbitrator. That's $10,000, $15,000 worth of expense. You can avoid all that up front by saying, here's the rate for the lease in the option period. The rate goes up 5% a year. Easy, right? We know math. Math is easy. We like those rules. Easy rules. Everything else is just an argument. It's going to cost a lot of money. And as a tenant, an option with a fair market value, again, doesn't really give you much, because you can already go get fair market value in 5 years from the same landlord. She's going to let you pay that because they don't pay commission. But if you fix your rent at fixed increases and say whether it's 3% a year increases during the option period or 5% or whatever they might be, you know exactly what you're getting. You send a letter exercising your option, and now the lease is extended 5 years. It's a really important term, especially if the tenant's going to do tenant improvements. They're expensive sometimes, a lot of times. And the tenant moving is a big pain. You got to change their stationery, you got to do all these different things. So negotiating an option in a lease is a really important term. Multiple options are great, but pay attention as the landlord side. If you're going to do that, you want to include language that says, language similar to if the tenant is in default more than 2 times during the lease, whether or not it's been terminated, their option rights are surrendered. That's a huge hammer, right? That tenant knows, I can't pay my rent late twice during my 5-year initial term, or I lose my ability to extend this lease. They should be able to exercise an option during a period where they're in default, even if it's the first time. And you put other qualifications that you can't assign this lease. If I enter into a lease with Stefan, I want to make sure that that's my tenant for my option period. I don't want to allow him to assign it without my approval. And if he does assign it, I want to have the ability to say, I'm not doing a deal with John because I don't trust John. I don't think he's a good operator. Stefan made his money selling his business. He was a good businessman. I want to be with him. Now I'm stuck with John, who is a first-time retail operator, and doesn't know what he's doing, and now I'm stuck with a bad tenant. So options are extremely important. I mean, again, one of the most important things for all of you as brokers to know is the more information you can provide at the outset of the transaction to both parties, the smoother the contract negotiation is going to go. If the contract is, if it's a simple LOI with, I get emails all the time. I need a contract written, here's the purchase price. What are we buying and selling? Who's the brokers? What's the due diligence period? What does that do? It drives up my client's fees because the broker didn't do his due diligence in getting the LOI prepared right. If there's questions, ask your attorney before you send the LOI, not after, not contract negotiation stage, because there are parties, particularly parties, I'm dealing with Chipotle on a lease right now. Chipotle's LOI is like 15 pages. And as an attorney, it took me an hour to read it because it's got so many convoluted, ridiculous things in it, because Chipotle's a big player and they can negotiate whatever they want because everybody wants one of them in their commercial building. Their LOI would not be understandable or comprehended by a non-attorney. That's how it's written on purpose. Because they want a landlord who doesn't want to spend $1,000 to have their attorney look at it, sign this LOI, and they will not bend. Their LOI is in concrete. And they've been very interesting how they negotiate it, but they're a very good operator and they know what they're doing. So if you get an LOI that looks like you don't understand something, make sure you get the understanding, whether it's to an attorney, your owner who has experience in this area, make sure you understand the terms that are going out in the LOI. So, mending contracts, and I'm going to try to be a little quick here. Mending contracts. So, contracts for real estate have to be in writing. You're supposed to amend them in writing, but you can also have what's called the statute of frauds is our bar, but there's something called estoppel. And it means if we've relied on an oral agreement, even though the contract says it has to be in writing, it can be enforceable. So if we have it in writing, it's going to meet the statute of frauds, it's going to be binding. Every amendment should address very specifically what we're talking about in the amended terms. It should be signed by both parties, and you really need to be careful that it sets forth all the different obligations, because it may be one thing, we're just changing the purchase price, but we also are now running up against the expiration of our contingency period. So do we want to handle that now? Let's do it in one document. They're 10 days out. They don't seem like they're ready to close. You're representing the buyer. You're adjusting the purchase price down because you've discovered a couple of the leases are lousy. We need 10 more days. Do it all in one document. Make sure it clearly sets forth the obligations. So oral agreements, brokers, be careful. This is a dangerous one, especially in tenant leases. Tenants will always argue. The broker told me I could get out of the lease if I just surrendered it by January 30th. Broker never said that, but they moved out and they abandoned, and they say, when you sue them, they say, well, the broker told me I could leave and I left everything in place. That's just the deal we made. Well, it's not a written modification of the contract. It's not something that meets the statute of frauds, but under California law, you can argue this estoppel argument, promissory estoppel, and it says it's an enforceable agreement. If there's any other consideration for an oral agreement, meaning you pay more rent or less rent, depending on who's the party to be bound, that can be an enforceable oral agreement. So as brokers, we need to be extremely careful, and property managers and even owners too, be extremely careful about what communications you make. And if you have a communication with a buyer or a seller, a tenant, make sure you follow it up with an email. It's, CYA, right? Cover your, what. So we send those CYA emails. This memorials our conversation 10 minutes ago where we agreed that, we would draft an amendment that would be enforceable upon signature to extend your due diligence period. That seems like a lot. It seems like a waste of time. That email will be so valuable later on if there's ever a dispute. 1 minute of your time can save hundreds of thousands of dollars in future litigation. Biggest post-contract disputes. Again, did they get their due diligence materials? Price renegotiations, be ready for them. They're going to come. Tenants, buyers, sellers, most of the buyers, they're going to come back and say, yeah, I like it, but I want to renegotiate the price. And that's where those deposits are important. That's where your inspection period is important, because they're going to come back to you. And I'd probably say 50% of my transaction, there's some request for reduction in price. Oh, well, we saw the tax rolls and we want a reduction in the price. Be ready for that. Title exceptions, I'm sure you've all seen a preliminary title report. Now they're all hyperlinked, saves us tons and tons of time. It's great, love that they do that. Look at the title. And if you're a seller's agent, look at the title before you list the property. Look and see if there's problems that you're going to need to handle in the future, because you know you're going to have to. Are there monetary encumbrances? Does your seller have mechanics liens against the property? Does your seller have tax fines? What is on the preliminary title report? That is going to be in the purchase sale agreement. It's going to be negotiated, but know what problems you have before you get into contract, because it's late and it gets expensive. Title issue, I tell every seller, make sure, even if they don't have a broker involved, pull your title report and send it to me. I need to see it. Did your neighbor file an easement that you didn't agree to that you need to get off before you can even put this property on the market? Is there someone with a memorandum of option that's expired 10 years ago, but it still shows up on your title report? Take care of those things. Closing transactions. I just get started early. Every time the transaction doesn't close, it's typically, in my experience, it's typically because we don't start those closing documents on time. Where, here's the preliminary closing statement. Let's get on the title company. Let's make sure they're working on it. Let's get that thing done. And the best thing to do is start early. Last minute closings, you're going to run into problems. Something's not off title, something didn't get removed off the title report. The title company is objecting because they don't want to insure because there's this one thing that wasn't removed. The seller hasn't provided their standard disclosures that they're a California corporation in good standing and made the representations to the title company. Get started early from the broker side. And then the most important thing, just a reminder, is disclosure disputes. Disclosure disputes, disclosure disputes. 90% of litigation in real estate after closing of escrow is about disclosure. Over disclose, document your disclosure, and make sure that you have records, evidence in any of your disclosure conversations. I love email. It's great. I mean, be careful what you write in it. Make sure that when you write an email, you're okay with it being on an exhibit this big in front of a jury. Be careful. I've seen some horrible things in some emails, and they are really bad in front of a jury. So that's really the basics of getting started, but I definitely want to open up the floor. Any questions, any topics you wanted to hear anything about, I'm happy to go over them. So I do business transaction work depending on the business. There are specific areas I'm a little bit careful with. Franchise law, stay out of franchise law, it's very specific. But make sure that, when you ask the questions, if someone is going to do a business transaction or a real estate transaction and you're interviewing that attorney, how many deals have you done? Have you done a lot of these deals? How many times have you sold vacant land? Because that makes a difference. You're interviewing the attorney to make sure, just because you Googled them and it says real estate attorney. I mean, I worked under some very experienced real estate attorneys when I started practicing law, who'd been doing it for 30 years. And I could ask them a question anytime. But make sure that the attorney you ask to do your help has done the transaction before. First time unsupervised is probably not a good idea.
What else, or how else you support brokerages with commercial? What other services you provide?
So I do leasing, I do purchase and sale agreements, I do easement issues. I don't really get into easement litigation anymore because it just takes so much time. And as the benefit, I think, to having an attorney like me, and there's a few of us out there that did both, because I came from McDonough, Hall & Allen. It doesn't exist anymore, but it was the biggest firm in Sacramento when I started practicing law. And they forced us to learn litigation. They forced us to learn transactional. And I have litigated a lot of what's in my own contracts. Some tenants, like force majeure during COVID. I had never even considered what a force majeure paragraph said until COVID hit. And tenants said, oh, I don't have to pay rent because of the pandemic. Well, thank God my lease is all set. I hadn't even thought about it. That in no event is the tenant's obligation to pay rent excused by a force majeure event. Now, force majeure is negotiated in every retail lease. So it's things like that by experience I've learned. I've litigated, I've read the cases, I know what they mean. And those are important things. Not every transaction lawyer does that, but it's what I do, and it helps.
Do you offer TC services?
Sorry?
Do you offer the TC services?
TC, what are you talking about?
Like transaction coordination?
No. So I don't do any, and typically, the rate's too high to have people do that. So I do get that question all the time. can you do that for us? We want to do no escrow, or we want to do no brokers when it's buyer and seller and they don't want to involve brokers. I'll refer them to a broker to handle that work because it's too expensive to have us do it.
Thank you.
No problem.
So what's the typical range of the fee for a commercial transaction?
So it depends on what you ask the lawyers to do. So if you have a form contract, you're using the Department of Real Estate form contract, which, buyer beware, proceed with caution, it has some issues in it. And you just want us to review that, it's probably going to be 2 hours of work. My rate's $4.50 an hour in Sacramento. I keep it on the lower end because I represent smaller buyers and clients. I don't represent Google or Facebook. But I was on a deal. We sold it was actually a mall, and I was working late at night, and this other lawyer we were having conference calls at 2 in the morning, and I said, "This is ridiculous. Let's just come back tomorrow." And he goes, "Why? We're making $1,000 an hour." And I'm not making $1,000 an hour. What are you talking about? And he was charging his client. This is years ago, $1,000 an hour. And there are attorneys in San Francisco I've had on the other side of deals that were $2,000 an hour. But they're getting paid by Facebook, they're getting paid by Google, and they don't even look at the bills. So typically, range in Sacramento, for a person my experience, I'm on the lower end, they do it on purpose. But I think the range for someone at my level, 22 years, is going to be probably in the 400 to 700 range. But the more work the brokers do in preparation, the more money they can save their clients. So if I get a deal that's got none of the things I need in it, and I need to draft a purchase sale agreement, add 2 hours. So, I always laugh. The brokers make all the money. They always think the lawyers do. The brokers make all the money, especially commercial.
Yes, kind of back to her question. So a friend of mine, he wanted to buy a commercial property. He's still trying to buy the property. But the seller saying he doesn't want to go through the broker. He wants to go straight to the lawyer to do the contract, to skip out on the commissions and, for his end. So you're saying that's the stuff that you don't do, that kind of stuff?
No, I don't do the transaction coordination. If someone came to me and said they need that help, a lot of sellers don't need brokers. I have clients of mine that they were brokers before, they became investors, now they're owners. They'll handle their own stuff. I mean,
Don't say that to them.
no, they'll do that. But I was going to qualify it. The problem is a lot of times sellers are too busy to really handle the things a broker would handle. Being a transaction coordinator, I mean, I've referred, especially in residential, not really commercial, because people just don't do that very often. But I've referred buyers and sellers to transaction coordination, like brokers are willing to do it for a flat fixed rate. I'll do it for $5,000. I'll be your transaction coordinator. I don't do it. I don't know any attorneys that actually do, that are actually practicing law. There are attorneys that are no longer practicing that might do that work, but we always use title companies. They'll do a lot of the work for you, but ultimately, I think it's a huge benefit to both parties to have a broker and an attorney involved. I've done a lot of deals without brokers, a lot of deals. A lot of times the nationals will have a person who's on salary to go out and find locations. They'll send the LOI directly to my client, and my client, if he doesn't have a listing agreement or manages the property himself, which some of them do, then they won't have a broker involved. But typically, I think it's everybody's safer. I think one thing to be a caution about is double ending a deal, being the broker for both sides. You owe fiduciary duties under California law to your buyer client and your seller client. In a lot of states it's illegal to do it. So I think it's dangerous. You got to be extremely careful in due diligence on both sides, because nothing your client tells you on either side, if you're doing both sides of the deal, is confidential. Because you know something. You might know that the property leaked 10 years ago, and you have to disclose it anyway, but maybe it's outside the period. So be careful on double ending deals. Be really careful on disclosure. Anything else? Go ahead.
So if the commercial property is listed and it's leased out, and the lease agreement has a term of first right of refusal, from your experience, do you ever see that be an issue?
Oh, sure. So there's first rights of refusal in several different forms, right? One is the first right of refusal for the adjacent space. One is the first right of refusal to buy the building. There's lots of different rights of refusal. They do get litigated a lot of times because the tenant will have defaulted, and now it's 5 years later, and they say, well, I have a right of first refusal on the space next door. And no, you defaulted. Here's your notice from 7 years ago. That right was lost. Mm-hmm. That's one way. The other thing that happens a lot is, and I just had this happen in a right of first refusal to purchase a property. The seller only provided the price, the closing date, and the basic, and it said it's all cash. And I didn't draft the agreement, the underlying agreement, and my client said, I don't believe this is a real offer. I have a right of first refusal, but I don't believe this is a real offer that this guy's making here. And he had nothing in his contract that required the landlord to disclose who the buyer was, you know, what other terms. So right of first refusals are very specific contract terms, should be negotiated and include very specific language. Again, I want to know the rules. So the whole rule of the game is I'm buying a property, I'm paying this much, and this is what I'm closing. I also, for a right of first refusal, I want those same set of sub-rules. What's the rule? How soon do I have to respond? What do you have to deliver to me? Those are really important. Really, that's a good question, because that's actually something that we just litigated a couple of months ago. Anything else?
I have a question.
Sure.
If I have a property for sale, it's, let's say, a farm, and the owner is the business user, do I do commercial leasing agreement and the business agreement?
Depends on what you're selling. So a lot of times you're just selling the real property and not the business. If you're selling the business with it, like their name, you need to have really two documents. And really what we do in those transactions, we do the business document first, and then the real estate document second. So I'm going to figure out what the deal is to buy the business. Are you buying the name? Are you buying my property? Are you buying my stock? Are you buying just the assets? What are you buying? And the real estate side is contingent on that transaction closing. So we'll do a business transaction, attach the purchase agreement to the business transaction, and say that the real estate side only happens if the business side closes. That way you protect a business owner who owns their property from losing their property and being a tenant on their own property.
That's right. Thank you.
No problem. So just in closing, just again, I would recommend, you know, engaging counsel early if you can. Some of your sellers won't want to, but I don't advise that. Before something gets bad, call your attorney. It's way cheaper to handle it before we get into a litigation than it is after. Amendments, again, talk to, if you're writing if then, talk to the attorney, because you don't want to practice law. All right? Thank you so much for letting me talk to you.